Hey out there, legal warriors. In this video, I'm going to cover a very common criminal charge in Washington state, theft in the third degree. You can think about it as shoplifting. And in this video, I'm going to cover first offense shoplifting. What happens? What's the procedure? What do you do about it if you get accused of it or a loved one does? And how can we get that case dismissed and hopefully keep it off your record so that theft charge does not affect your future? If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm has been defending people charged with crimes all throughout Washington state for more than 20 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. First, I'm going to go over the definition of theft in the third degree. It's a law in Washington state that says, hey, if you take or exert unauthorized control over the property or services of another, and for a non-felony, it also has at a value of less than $750, that person is guilty of the crime of theft in the third degree. What's the maximum penalty? Well, it's a gross misdemeanor. It's a non-felony, but it's very serious. The maximum penalty is 364 days in jail, and a $5,000 fine would be the maximum. There is no mandatory minimum penalty on a first offense theft charge in Washington state. Now, if the person accused of theft is 18 years old or older, it's going to go to adult court. If the person accused of theft is 17 years of age or younger, it's going to go to juvenile court. Now, if it's a first offense theft in Washington state for a juvenile, hopefully that case will be sent to diversion, and you don't need to watch much more of this video. You can follow the diversion rules and hopefully keep that from being on the juvenile's record. Now, for everybody else, if we get accused of theft in the third degree, we're going to have to go to court. And when we go to court, that first court date is an arraignment. And if you can, you want to try to have an attorney by your arraignment. If you can't afford an attorney at your arraignment, you need to ask the court how to apply for a public defender so you can get appointed the public defender to represent you, because you do not want to represent yourself in any type of crime, especially one where you can go to jail for almost a year. So at the arraignment, the court is only going to take a plea of not guilty. They're not going to really talk about what happened. You're not going to see the store personnel who stopped you or the police officer who gave you a ticket, or maybe you just got one in the mail and you never saw a police officer. You're going to plead not guilty, and the court's going to set conditions of release on you. They're going to say, hey, don't go back to the store. If the store was at a mall, they might say, hey, don't go back to the entire mall. And then they're going to set a pretrial hearing. A pretrial hearing, there's usually multiple pretrial hearings. That's a hearing where the attorneys, the prosecuting attorney who represents the government, and your defense attorney, either the private attorney like myself or my firm, or a public defender, they sort of informally talk about the case and move it either towards a resolution or towards a trial. Now, in most theft cases, there's never going to be a trial because usually they've got us on tape, or the store personnel, or we admitted it. Usually if someone's accused of theft, they're having a hard time with anxiety, their emotions. They don't know why they did it. I think much more often we see that type of case than someone who's stealing for drugs or things like that. Oh, those cases exist too. So at that pretrial hearing, the attorney and the prosecutor are going to sort of work towards a resolution. And in my opinion, the only acceptable resolution for a first offense theft charge is dismissal. But how do we get it to dismissal? I mean, that might be while you're watching this video. I'm scared to death. What's going to happen to me? I need to make this charge go away. Well, there's several different ways that attorneys can get a first offense theft charge dismissed. And the most common way is through a special law called compromise of a misdemeanor. Now, we've have some other videos on that, and hopefully my team is going to put up a link to that video here. But compromise of a misdemeanor is RCW 10.22.010. RCW means Revised Code of Washington, if you want to type it into the computer or your phone and look it up yourself. But basically, it's a law that says if a victim of a crime has a civil cause of action, that means they'd be able to ask for money from you for your wrongdoing, and that victim appears in court, we say that means in writing, and state they've been civilly satisfied for their damage. That means you paid them and they signed something releasing you from civil liability. If your attorney presents that with the motion, the court, in its discretion, which means they don't have to, but if you have no record, hopefully they're exercising discretion in your favor. The court, in its discretion, can dismiss the case against you. And the prosecutor isn't really part of that. Some prosecutors will want to object, but if you read the statute, it doesn't say it needs prosecutorial agreement. It doesn't even say it needs the agreement of the victim. The victim just has to state they've been civilly satisfied, they've been paid. So that doesn't work in every type of crime, like a possession of drugs. There's no victim to pay, right? But in a theft charge, it does work because the stores in Washington State have a special right to recover money from someone, even if they recovered the property. Let's say you took some clothes from Nordstrom and they got all the clothes back. Well, they're not out any money. Why would they be able to sue me? Well, there's a special statute. And a lot of people think that's bad for the person accused, but it's really good for the person accused. Because that statute says the shopkeeper is allowed to ask for money, basically liquidated damages for their enforcement costs, for their security, to sort of recoup from people that make their security necessary. And they can ask for a certain amount of money plus the amount of property that was wrongfully taken, even if it was recovered. How does that work? Usually the shoplifter will get a demand in the mail from some law firm, oftentimes in New York or Florida. Some places like Costco don't do civil demands, so that's unfortunate because that's one less way out. Some stores don't do civil demands, but many stores do. Some of the big ones, Nordstrom, Sephora, different chains out there that have a big national footprint will usually have some way to try to recover this money. So if you happen to get a civil demand in the mail, hang on to that and work with your attorney. Typically, we don't want our clients paying the civil demand themselves because they don't have any release they can send to have signed and sent back. It's not, paying the civil demand does not make your case get dismissed. And usually the demand for money will say, this does not affect criminal liability. Well, that's true, it doesn't. They're trying to warn you. But we can use a release to ask the court to affect the criminal liability under the law. Doesn't matter what the alleged victim says or wants. It just matters whether or not that they've signed off, that they've released you civilly, and then it's up to the court to decide whether or not you're worthy of a dismissal under that statute. So if you were working with my office, we would try to get the payment for the civil demand from you. We would write out a trust account check to the store in question. We'd ask them to sign our civil release and send it back. And if we get it back, in the appropriate case, we would bring a motion in court to dismiss the case. And if it gets dismissed, it's dismissed. It's over, right? There's no probation. There's no plea. There's no fines. There's no anything. Now, the civil demand, the compromise and misdemeanor statute does allow for the court to impose court costs. Some courts will have a small cost. A lot of courts won't, but it's not a fine. It's just a way to reimburse the court for some of their time spent handling your case based upon your alleged wrongdoing. So that's the gold standard to get a theft case dismissed. Next, we usually try to look at something called a stipulated order of continuance. Many courts have something called a stipulated order of continuance. And when I say courts, some courts don't allow those type of things, and most courts do on a non-felony matter. Think of a stipulated order of continuance as not anything that you have a right to. It's not a statute. It's a way that prosecutors can try to resolve a case if that resolution is available and allowable in the court in question. It's a contract between the government through the prosecuting attorney and the defendant through their attorney, where the defendant agrees to do certain things. The typical SOC might be have no crimes for 18 months, complete a theft awareness class, pay $150 of court costs, a lot more in some other courts, make sure the victim's reimbursed, maybe even do some community service, okay? And if you live up to the terms of the SOC, usually the case agreement calls for dismissal. If you blow it and you have another crime, or you don't do what you're supposed to do, you don't complete things you're supposed to do, then the prosecutor can make a motion to enforce the SOC, which they would say revoke it. And typically the defendant is given up the right to a trial, stipulated to the report, and then for all intents and purposes, that would lead to a conviction. The court reads the police report and then usually enters a finding of guilt if the report has sufficient evidence to support a finding of guilt. An SOC is usually really good because we're not pleading guilty, we're not being found guilty. So I really like it if we can get an SOC offer, because then our clients control the outcome by their future behavior. And usually being in trouble once is enough to scare people straight and not ever have it happen again. What else can we do? Well, you can also try to get a prosecutor to do a straight dismissal without an SOC. Some courts' SOCs aren't available, and so a prosecutor might have a pattern of behavior where if you do certain things that they will dismiss it outright as opposed to convicting you. If they won't do that, then we're looking at trying to get a deferred sentence. A deferred sentence is where we're found we have to plead guilty to the theft, but we get a deferred sentence, a period of probation, where at the end of the period of probation, the court will undo the guilty finding and then dismiss the case. So it ends up in the same place with a dismissal, but we are guilty of a crime during that period of deferral, at least from the way I look at it. Different attorneys will read the statute differently, but I think that's the prevailing way that we explain it to people, and the court would also explain it to a defendant. What if I'm innocent, Lance? I didn't mean to take it. You have the right to try to go to a trial as well. The sad part is so many people are sophisticated in their ways of trying to steal things. They usually have mimicked innocent behavior so much that a truly innocent person is not going to be believed, right? Hey, I walked out and forgot to pay for it. What if you really did? Sure you did is what they're going to tell us. That's what everybody says, right? I'm willing to pay for it now. That's what everybody says. I scanned it wrong. Self-scanning. That's what everybody says. So sometimes we can get really crucial evidence, some video that supports innocence, but usually it's going to be barking up the wrong tree, so to speak, trying to assert innocence when there's all these other ways that we can get a charge dismissed. Because in my opinion, I don't care how it gets dismissed as long as it gets dismissed. If you feel wronged by the store's actions, we can deal with that emotionally another way. What we're trying to do is make sure you don't end up with a conviction that's going to mess up your job, mess up your future, mess up your reputation, right? We do not want that to happen. If you did do wrong and took something, remember, it's not because you're a bad person. Usually we're under stress. We have a strange and altered bodily feeling or emotional feeling, and acting out of character is one way to change that. Some people steal things. Some people drink too much. Some people get in fights. Some people gamble. Some people, surf the internet for all types of things that they shouldn't be surfing for. The bottom line is, if you get accused of this, it's not hopeless. Do not give up hope. Most of these can get fixed if you follow good attorney advice, if you don't panic, if you stay positive, and do what your attorney tells you to do. So I hope you found this helpful. If so, please like and please subscribe. More people get the help they need, and more importantly, if you have a criminal charge in Washington State, feel free to give my office a call. We've been doing this for more than 20 years. If we get on board, we'll identify what happened, and we will do everything we can to chart a path to your future success. Thank you.